Hello, everyone, and welcome to today's webinar from the National NAGPRA program on the revised NAGPRA regulations. My name is Melanie O'Brien, and I am the manager of the National NAGPRA program. This session is being recorded and will be made available after the session concludes. You can find recordings on our YouTube channel, as well as on the NAGPRA program events page. There is no chat for today's webinar, but there is a Q&A option. If you have a question, you can use Q&A. You can find it at the bottom of your screen to submit that question. I've prepared a short presentation for today's webinar. And I have allowed for plenty of time for questions at the end of the presentation. I do see that we have one hand raised. If you can put your question in the Q&A until we open up. Okay, so to start today with an overview of the revised regulations under NAGPRA. Um, 43 CFR Part 10 are where the regulations for NAGPRA are housed in the Code of Federal Regulations. The revisions represent a full revision to the implementing regulations and clarify and simplify the regulations, but provide requirements that are very similar to the prior regulations. And these regulations apply to all museums, and that term is used intentionally but broadly defined under the Act and the regulations, as well as all federal agencies. The regulations outline two different regulatory processes. The first for protection of human remains and cultural items on federal or tribal lands, and the second for repatriation of human remains or cultural items by museums or federal agencies. The proposed rule for these regulations was published on October 18th, 2022. The proposal that was published was based on 3 months of tribal consultation that was conducted in 2021, 6 months of interagency comment and review that was conducted in 2022. And the proposed regulations specifically sought input from all parties that are affected by these regulations. During the public comment period on the proposed rule, we also held tribal consultation as well as public listening sessions. I see several hands raised. If you have a question or a concern, if you could place that in the chat. I see people don't see my slides. I'm going to try sharing again and see if that fixes the problem. Hopefully everyone can see my slides now. All right. Great. I think that we fixed whatever problem was happening with the presentation. I apologize. So again, the proposed rule was published in October of 2022. By the end of the public comment period, which ended January 31st, 2023, we had received 181 public comment submissions. In looking at each of those comment letters, they yielded over 1,800 specific individual comments. Some of the comment letters were many pages, some as many as 30 or 40 pages long. And those comments, when we broke them apart, yielded just around 1,800 individual comments on specific portions of the proposed rule. The comments that we received on the proposed rule came from a variety of types of submitters. The largest group were individuals. 95 individual submissions were received. We received 48 individual submissions from federally recognized Indian tribes, although 2 of those represented multiple Indian tribes, so the total number represented is 55 Indian tribes. In addition, we received comments from museums as well as from museum and scientific organizations. Additional comments were received from Native American organizations. All of this information you can find in the final rule itself. In the first few pages of the final rule, you will see these tables and reflecting the number of submissions and the breakdown of the kinds of comments we received. This breaks down the comments that we received by the largest numbers. Again, the numbers here are referring to the 1,800 individual comments that we received, and 102 of those related to changes to affiliation in the proposed rule. And then from there, different groupings of those comments based on the topics that we're commenting on. I'm going to go into more depth about some of these, but again, I encourage you to look to the final rule where each and every comment is addressed. In addition to the information that was in the table, we received additional comments, 109 comments, which were generally supportive of the proposed regulations, as well as additional comments that related to issues related to or outside of the regulations themselves. And lastly, although it's a small number of comments, it created a significant change in that we received comments requesting that we change from the proposed rule, which used business days to calculate timelines, to calendar days. In developing the final rule, we took all of that public comment. As I said, we reviewed and responded to each and every one of those public comments. In addition, we considered federal agency input on the final rule, but the priorities in developing the final rule were the Department of the Interior's priorities for this rule, as well as the input that we received from Indian tribes and Native Hawaiian organizations. To explain a little bit more about what the Department of the Interior's priorities were for this regulation, the top priority for the department was to ensure that these regulations provide a clear path for the expeditious disposition and repatriation that is required under the law itself. To do that, we sought to clarify and improve the systematic processes, to provide a step-by-step roadmap with specific timelines, and to align the processes with the Act and congressional intent. In addition, the department's priority was to incorporate input from Indian tribes and Native Hawaiian organizations to the maximum extent possible. That included requiring deference to Native American traditional knowledge in the definitions of the regulations, and to ensuring that the rights that are afforded by the Act to lineal descendants, Indian tribes, and NHOs are clearly recognized with these regulation changes. As a result of the public comments, we made some changes to the proposed rule. And this slide summarizes those changes. We have, in the final rule, removed geographic affiliation and preponderance of the evidence as used in the affiliation section. I'll talk about that a bit more in a little bit. We have also removed Indian groups without federal recognition from these regulations. And we have removed the requirement that was in the proposed rule for Indian tribes and Native Hawaiian organizations to submit written requests to consult. We have revised the definition of consultation from the proposed rule to include goals as well as a process, more of a process for consultation. We have required free, prior, and informed consent before any exhibition of, access to, or research on human remains or cultural items. I will also talk a little bit more about that provision. We have extended timelines from the proposed rule. The proposed rule had a 2-year timeline for updating inventories. We have extended that to 5 years. In addition, we have extended timelines for evaluating competing claims or requests, and a required response from federal agencies to museum statements on federal collections to be 6 months. In addition, other timelines were adjusted based on the change from from business days to calendar days. Lastly, although we received a lot of comments on the definitions and application of the term possession or control, we have not made changes to that definition or its application. The final rule is a very long document, and it is divided into 4 sections before the regulatory text begins. If you want more information about any of what I've previously presented, you can find it again in the final rule itself. In section 2 in particular is a summary of the public comments as well as a response to each one. There are a total of 124 summarized public comments and Department of the Interior responses in that section of the final rule. In the third section, there are additional responses to direct public engagement and requests for comments. Before the regulatory language itself begins after section 4. In looking at the summary of comments and responses, I wanted to highlight this table of contents to that. Again, it's the longest section of the final rule, of the beginning of the final rule. It covers those 124 comments, and I've highlighted here where you can find the comments and responses on some of the top issues that were raised through the comments and that I outlined previously. This is a great way to find exactly a comment or a response that you might be interested in learning more about or reading the full response to. I'm going to go through just a couple of them here today, and then we will have plenty of time for questions. As I mentioned, we received a number of comments requesting changes to affiliation as it was in the proposed rule. In particular, it is comment 58 to 61 that addresses both the comments that we received as well as the changes in the final rule. We received 27 comments that were generally supportive. We received 11 comments about the specific types of information used for affiliation. We received 23 comments on the use of the term preponderance of the evidence under affiliation, and we received 41 comments on the proposed rules use of geographical affiliation. As a result, in the final rule, we have removed from the section on cultural affiliation, we have removed culturally unidentifiable, geographical affiliation, and preponderance of the evidence. We have shifted a focus in this section on the simple and collaborative procedures needed to determine cultural affiliation. And I point you to our website, the nps.gov/NAGPRA, where you can find a page specifically dedicated to determinations of cultural affiliation for human remains and associated funerary objects. This again is a website that summarizes the content of the regulations itself. Next, I wanted to briefly describe the comments and responses we received on duty of care. You'll find these in comment 12 to 17 in the final rule. We received a few comments that objected to the duty of care requirements as proposed. We received additional comments that supported it as proposed. And then the largest number of comments requested strengthening of the provisions as proposed. In addition, an additional 45 comments we received specifically about scientific study under these regulations. In response, we have drafted duty of care requirements in the regulations themselves that require museums and federal agencies to care for, safeguard, and preserve human remains and cultural items in their collections or in their custody. And in addition, we have 3 subpoints in that duty of care requirement. The first being to consult on storage, treatment, and handling. The second, to make reasonable and good faith effort to incorporate and accommodate requests from consulting parties. And the third is to obtain consent prior to the exhibition, access, or research on human remains or cultural items. We have prepared a frequently asked questions document related to this duty of care requirement, and you can find it again on the NAGPRA website, nps.gov/NAGPRA. Navigate to the policy section under law and policy to find this specific document, or take note of the URL listed here. Another change that we've made to the final regulations that is important to note are changes in the timelines. We received 16 comments that either supported the timelines as proposed or felt that they were actually too long or of benefit to museums and federal agencies. We received 30 comments that objected to the timelines as being too short, unrealistic, unworkable, or unachievable in the proposed rule. Again, as I mentioned earlier, the proposed rule provided a 2-year timeline for updating inventories of human remains and associated funerary objects. In our response, we stress that these regulations do not impose a timeline on lineal descendants, Indian tribes, or Native Hawaiian organizations to make responses or to request repatriation. It is our intent with these regulations to allow lineal descendants, Indian tribes, and Native Hawaiian organizations to define what expeditious repatriation means. We feel that if museums and federal agencies are engaged in meaningful and effective consultation, any pressure around the timelines required by these regulations can be alleviated. We have provided additional guidance in our steps to repatriation document, along with some hypothetical timelines that might assist museums, federal agencies, as well as Indian tribes and Native Hawaiian organizations in understanding where in these steps the timelines are triggered. Again, I want to stress that these regulations do not impose timelines on lineal descendants, Indian tribes, or NHOs to either respond to a request for consultation or to make a request for repatriation. So rather, it provides timelines and requirements for museums and federal agencies to take certain actions to make repatriation possible and to allow for those requests from Indian tribes and NHOs. This again goes back to that sort of outline of where you can find specific comments and responses. I'm going to leave this up for a minute while I look at the questions. The first question I received was if the webinars in this series will be different. Yes, I've provided a summary at the end of what we intend to cover in each of these webinars. We are, though, happy to respond to requests that you might have for specific topics. Again, I apologize for the technical problems at the beginning. I think that we have resolved that issue. And I do appreciate your feedback, those of you who supported it in the Q&A. There is a question about all museums and if I am referring to private museums that receive no federal funding. No, when I said museums as broadly defined, I mean as defined by the Act itself and the regulations. The definition of museums has been the same since the law was passed in 1990. That is any institution, including state or local government or institutions of higher learning that have possession or control of human remains or cultural items and that receive federal funds. I will note that the definition of receives federal funds, which was included in the previous regulations, has been included in these revised regulations. We have expanded the definition to help clarify any confusion around what that term means. And I would direct anyone who has a question or concern about whether a museum receives federal funds and therefore is subject to NAGPRA to review that definition of both museums as well as receives federal funds. There was a request for a clarification on the removal of Indian groups without federal recognition. Does this mean repatriation can or cannot happen with non-federally recognized tribes? Thank you for the question, Heather. The answer is that repatriation to a non-federally recognized Indian group or an Indian group without federal recognition can only occur under these regulations if that Indian group partners with a federally recognized tribe. There's no path for a direct repatriation from a museum or a federal agency to an Indian group without federal recognition in these regulations. Rather, there are paths to repatriation through the federally recognized tribes in these regulations. Someone asked if I was going to keep this presentation in PowerPoint online so it can be referred to. Yes, we will be posting a recording, provided there are no technical issues, to our events page as well as to our YouTube channel. And we will also be adding the PowerPoint presentation as well. Okay. Another question, if the links to the FAQs can be shared in the chat so we can access and download without searching the website. And thank you to those of you who posted those links in the Q&A. Hopefully you can all see that response. I will leave that open for now. Another question about summaries. Our museum sent summaries by the first deadline over 30 years ago. Are we expected or obligated to send them out again? No, the expectation or obligation, I should say, is more inappropriate, is for any newly acquired collections or collections that were not previously represented in your summary. Those you would need to share information with tribes again on, again, summaries which contain unassociated funerary objects, sacred objects, or objects of cultural patrimony. There is no obligation under the revised regulations to update or resend summaries that were previously submitted. The obligation I'll add for any unassociated funerary objects, sacred objects, or objects of cultural patrimony is for a museum to respond to a request to consult. There's a question specific to the state law in California, commonly referred to as Cal-NAGPRA. And the question is, where do we add the non-federally recognized tribes that we have consulted with and wish to be added to the notice? In the last notice that was published, non-federal consultation partners were not included in either an NIC or an NIR. Under the federal process, again, there is a limitation to the tribes that are recognized. I should say, there is a limitation to the tribes that are identified in a notice of inventory completion or in a notice of intended repatriation to only the federally recognized tribes that are eligible to receive repatriation of either the human remains or the cultural items. Therefore, there is not space within the federal process for the non-federal Indian groups that you might have consulted with or partnered with. We appreciate and understand that this is an issue across the United States. It is not just an issue in California. We will be providing some additional guidance on this issue, both specific to California in conjunction with the Native American Heritage Commission in California, but also broadly for across the United States how museums and federal agencies could choose to engage with Indian groups that are not federally recognized and how a process might work. There is a question about if I could tell you which subpart the definition of receives federal funding is under. Yes, it is in section 10.2 of the regulations, and that is the definitions section. If I can do so without crashing my computer, I will try to pull up a link for you and put it into the Q&A to 10.2 definitions. There was a request for me to talk a little bit about the option for a museum or a federal agency to conduct a reinterment rather than a repatriation. And I would be happy to do so. I'm going to pause on that question for right now, and perhaps we can talk about that at a future webinar session, or if we have time in this session. Okay, another question, has the new regulation expanded the definition of cultural material, or does it refer to that cultural material that was previously included in the law? I appreciate the question. The term that's used under the law is cultural item. In the act itself, cultural item means human remains or the specific kinds of cultural items that are identified in the act by definition. So unassociated funerary objects, associated funerary objects, sacred objects, or objects of cultural patrimony. We have made a change in the final rule to exclude human remains from the definition of cultural item. This was done at the request of many Indian tribes and Native Hawaiian organizations who felt that the definition of cultural item referring to human remains was offensive and insensitive. So we have separated the definition of human remains from that of cultural item. In relation to what the definition of cultural item is under the revised regulations, we have tried to clarify the definitions, as well as ensure that the definitions include input from Indian tribes and Native Hawaiian organizations, as Congress intended in the initial definitions. There's more on this in the section C of the comments and responses we received. We did receive a number of comments, both on the definition of cultural item, but also on the specific types of cultural items and the inclusion of the term according to Native American traditional knowledge, which is included in each of those definitions in the regulations. Again, I want to stress that while this is a change to what is written in the regulations themselves, it is not a change from what Congress intended. There's clear intent from Congress that these definitions would vary according to each tribe, village, or Native Hawaiian community that might be seeking the return of its cultural items. There's another question here for the duty of care requirements, consultation prior to exhibition access or research. Does this only apply to objects for future display or for those currently on display? Thank you for the question. That's a question that we have received a lot by email over the last week or so. It is a question that we've responded to in our duty of care guidance. And it is up to the museum or federal agency to evaluate what it knows about the objects that are currently on display. So where a museum or federal agency has human remains or cultural items that are on display, it should evaluate what it knows about those items, but also its consultation record on those items to determine whether or not it needs to consult further to obtain consent for that display or exhibition, or whether it can continue with its display or exhibition. I can point you to several news articles that have outlined how museums have been handling this. There were a series of articles published last week about the Field Museum and its decision on covering exhibitions. In addition, today there was an article or a press release, I should say, from the Denver Museum of the Denver Art Museum, responding in how it is handling these responsibilities. So again, it is up to each museum to make that determination. There's a question about that there were no comments received by Native Hawaiian organizations on the proposed rule. I will say that we did receive a significant amount of input from Native Hawaiian organizations prior to the proposed rule. Again, as a reminder, we conducted tribal consultation, including Native Hawaiian consultation in 2021. We received extensive comments both from a variety of Native Hawaiian organizations, as well as some comments from the state of Hawaii itself. And that provided some input and impacted how we proposed these regulations in 2022. All right, there's a question again to clarify the requirements for consent before research, access, or exhibition. Again, that consent is required for those human remains or cultural items that are subject to NAGPRA. So it is important to note the distinction there, that the duty of care requirements apply to human remains or cultural items as defined by the Act and the regulations. Another question about the definition of objects of cultural patrimony. The question is, if we have objects in our collection where all signs point to them having been made for trade purposes, should we still be consulting with tribal nations for confirmation or permission before displaying them? Again, it comes down to what you know about the object itself. Certainly what you're stating here in this question is that you know that they were made for trade purposes. That alone is not enough to necessarily exclude an object. However, I would look to other information you might have, as well as look to other objects that have been repatriated to assist you in making this evaluation. Regardless, though, I would say that consultation is important here, even just to try to identify the type of item and whether there is a sensitivity or not. I think that the answer to most questions is usually to ask, to start a conversation, and that would certainly be my response here. Okay, another question about what museums do about objects that are currently on exhibit. Well, again, it's up to the museum or federal agency to evaluate what it knows about objects that are currently on exhibit, to decide whether there is sensitivity, potential sensitivity there. And then, of course, again, to ask, to start a conversation about the exhibition or objects that are on exhibit. We have provided in our guidance document some suggestions for how a museum or federal agency might temporarily cover until it is able to make that assessment, or other options for a museum or federal agency to take intervening steps for those objects. I will say that we know, and this has been expressed in other venues, that there are objects on display that tribes have requested be removed from display. If you know that your museum has objects on display and tribes have made requests already for those to be removed, those would be the top priority, I think, for a museum or federal agency to reevaluate the exhibition or display. Another question about the summaries. I'm unsure if our museum sent copies of our summaries to the National NAGPRA program, my office. Should I contact your office and ask, or if you do not have copies in paper form, should they be resent? You can certainly ask us by email, and we'd be happy to check our files and let you know what we have on file. You're also welcome to go ahead and send us what you have if you want to be sure that we have it in a digital format. We have, over the last 10 years, digitized most of our inventories and summaries, so we probably have it. We definitely have paper copies of everything, and we'd be happy to work with you directly. Anybody can reach us by emailing NAGPRA_info@nps.gov. That's NPS for National Park Service. Further questions about the requirements for consent prior to exhibition, and if this pertains to a wider group of items than the cultural patrimony items that were discussed or defined. Again, it applies to any item, any object that might meet the definition of unassociated funerary object, sacred object, or object of cultural patrimony, and then, of course, to human remains and associated funerary objects. Another comment that it's almost impossible to figure out what is a sacred or cultural patrimony object except through consultation. We would absolutely agree with that. And there are provisions in the law for and in the regulations for Indian tribes and NHOs to consult with museums on those objects to determine if they meet those definitions of sacred objects or cultural patrimony objects. Therefore, it is incumbent upon a museum to look at its own records of consultation on those objects and to find out if it has information already, or if not, to ensure that it has gathered the information it does have about an object and has made that available to tribes who may wish to consult. Oh, we have a lot of questions, and I'm working my best to get through them all. I will continue to work through the questions as we go today. We have about 45 minutes left in this time slot together. Before I go back to answering questions, I would like to just highlight a particular change that impacts those of you who are actively working on NAGPRA repatriations right now, and we wanted to be sure that we're communicating this directly to you. There have been changes to the notice publication process that are important to make note of. We do have new templates that are available and a few that are forthcoming. It is important to note that notices that are submitted to the National NAGPRA program will be published as submitted. There is no longer a review or a final sign-off process in the notice publication. Previously, if a notice was submitted to our office, it was considered a draft notice. We would review it, make suggested edits, return it for a final approval. To streamline this process, at this point, under the revised regulations, the National NAGPRA program will either accept or reject a notice for publication. There will not be a back and forth or an opportunity for a museum to revise its submission. Therefore, it's important that museums submit notices, museums and federal agencies submit notices that they are ready to publish. It is also important to note that in the revised regulations, the notice should be sent to consulting parties with a copy to the National NAGPRA program to publish. So it is important to note that the procedures here are not just to submit to the National NAGPRA program, but to submit to consulting parties that notice, whatever type of notice it might be. It's also important to note that the revised regulations have removed any amendment or correction notice. Therefore, if there are additional human remains or cultural items that are connected to or related to a previously published notice, those should be put into a new notice. For federal agencies, there has been a change to how notices of intended disposition will be published. Under the previous regulations, they were published in newspapers twice, 2 weeks apart. But now those notices of intended disposition for federal lands will be submitted to the National NAGPRA program to be published in the Federal Register. And again, as I mentioned, under the revised regulations, the National NAGPRA program will accept or reject notices within 21 days of receipt, and publication will follow 5 to 10 days after approval by the National NAGPRA program. And we have updated our website on notices to assist you with understanding this process. And as a reference, that link is here on the screen. By means of an example, this is the 2024 Notice of Inventory Completion template. It was updated last Friday. It was posted to the website over the weekend. I had, again, some technical difficulties last Friday that prevented me from getting it published. But it is there now and is available on our templates page for anyone to access and to review. There is a one-page instruction at the beginning, followed by the template, and each of the highlighted sections is for the museum or federal agency to fill in. Again, I encourage all of you to take a look at the new revised template that is available, and we will be working on making others available as quickly as possible. This is what I had promised you, an outline of what we are working on and preparing to share the third Friday of every month. Right now, we've prepared to present a deep dive into the requirements of Subpart C, that is the repatriation requirements, repatriation by museums and federal agencies. That will be on February 16th, again at 1 p.m. On March 15th, we will do a closer look at the consultation requirements under NAGPRA. On April 19th, we will look at notices under NAGPRA. The rest of the year, we have not quite determined. We certainly have lots of ideas of other topics that we could present, but we welcome your input. So please suggest topics or suggest additional frequently asked questions by emailing us at nagpra_info@nps.gov. As I mentioned earlier, recordings as well as the registration for this webinar series is available on our program event page. I will, I'll leave this up while I try to address some of the other questions in the chat. A question about if NAGPRA bears on the display or publication of photographs and illustrations of funerary objects by a museum. If so, do these images need to be taken down from online publications, such as educational websites that were published before the NAGPRA revisions? The duty of care requirements only pertain to the cultural items themselves, to the human remains or cultural items themselves. They do not speak to photographs or illustrations of those objects that the museum might have. However, we are aware that in many cases, images, even illustrations of certain objects are sensitive to tribes, and tribes have requested in the past that they be removed. So as the answer to most questions, consultation is key here. And it would be important to seek some input and advice from the related Indian tribes or Native Hawaiian community on a question of those illustrations or photographs. Related to this question, does this apply to publications or presentations related to collections? NAGPRA applies to outside of a museum, such as at conferences or professional journals. Again, the provisions of duty of care only relate to the human remains or cultural items themselves. Any other publications or presentations that might use the image of those objects would be, could potentially be very sensitive and should be consulted on, but they are not, there's not a prescription in these regulations that address those. A similar question about online databases, catalogs that are viewable to the public. And I would say the answer is the same. Those can potentially be incredibly sensitive, and we would encourage consultation on them. There's a little bit of back and forth about why drawings or images of burial objects would be made available publicly in the first place. Again, images of Native American human remains or cultural items is an incredibly sensitive topic, and one that should be the subject of consultation. Okay, a question regarding the provisions under 10.1E on the delivery of written documents under these regulations. There's a requirement for email with proof of receipt. Is there an approved method where written documents could be sent? Could I specify what proof of receipt for an email is? Is it a send receipt, a delivery receipt, or a read receipt? Any of those are options if they're available to you through your email system. The send receipt is the proof of receipt that you need to have in order to show that the email was sent. If you have options for delivery receipt or read receipt, those are good options to include to give you more information about how your document was delivered. But provided that there is some proof that the email was sent through an electronic system, that meets the requirements. There is an additional discussion in the final rule about this issue, as well as some suggestions for how you might show a proof of receipt. I will say that even beyond email, following up an email with a phone call to confirm receipt is another way of achieving the required proof of receipt. A question about the new templates and when they will go live. Will there be a template for plan of action and a comprehensive agreement? And when will a repatriation statement template be available? Yes, both of those documents are under in draft form right now. I should say all of those documents are in draft form right now. We will probably prioritize a repatriation statement template before we get to a plan of action or a comprehensive agreement. Again, plan of action and comprehensive agreements are mostly the same If anything, there are fewer requirements in the revised regulations for a plan of action than in the previous regulations. So you can use what you have been using for plans of action or comprehensive agreements. For those of you who may not be aware of what those are tools that federal land managers may use in dealing with discoveries or excavations on federal or tribal land. Those are particular to subpart B of the regulations on the disposition or protection, I should say, of human remains or cultural items on federal or tribal land. We are working on those templates and we will be producing them. You can check our templates page for that. We will include dates for when we've updated that information. And we will be prioritizing a repatriation statement template as soon as possible. What does the new duty of care language mean for allowing access to collections for faculty or students, research, and collection tours? The term research seems very broad, and I would like to understand if this new language means stopping any access to collections without approval from tribes. Specifically, referring to items other than funerary objects or ancestral remains, which we do not allow access to. Thank you for the clarification. Again, I think the answer, much like the answer around exhibits, is what do you know about the objects in question? Have tribes already requested that they be restricted in some way? Then honoring that request is definitely a first step. Where you don't know, where you haven't had consultation, you may wish to restrict access until you can have that consultation to ensure that you aren't violating that duty of care requirement. Again, it is difficult for a museum or federal agency professional to know what the sensitivities are around these objects until consultation has occurred. So certainly consultation is an important part of figuring out what you restrict access to. Okay, the online guidance for inventories on our webpage shows a table that states that if a museum has human remains or associated funerary objects that were not published in a notice of inventory completion by January 12th, 2024, they must submit an inventory by January 10th, 2029. However, we do not see that in the new regulation deadlines at 1010D2. Can you provide a citation for the 5-year timeline? Yes, in the next paragraph, it is in 1010D3. That is the paragraph that contains the deadline of January 10th, 2029, which is a 5-year deadline for updating inventories. Again, inventories are for human remains and associated funerary objects. Where you have human remains or associated funerary objects that were reported in an inventory previously, but have not been published in a notice of inventory completion, then the museum is required to do 4 things. And again, this is at 1010D3. By January 10th, 2029, a museum must, or a federal agency must, initiate consultation, consult with consulting parties, update an inventory, and submit the updated inventory to consulting parties and to the National NAGPRA program. Another question, does consultation mean only with tribally appointed officials? We get lots of information on what might be cultural items from artists, elders, and other knowledge holders, but they are not NAGPRA representatives for a tribe. So we have tried to clarify in the regulations the consultation process. In initiating consultation, a museum should send an invitation to consult with any lineal descendant or potentially cultural Indian tribe that is potentially culturally affiliated. The invitations to consult, again, go to either the lineal descendant or to the Indian tribe. In the process of consultation itself, the museum or federal agency should ask the museum, should ask the Indian tribe or Native Hawaiian organization who the authorized representative is. It is up to the Indian tribe or NHO to identify who is representing them in this consultation work. That can include traditional religious leaders if the tribe wishes to do so, but the consultation should be with the representative that is authorized by the tribe. A question about who bears the cost of repatriation of human remains and funerary objects. The cost to comply with the requirements and the regulations for an inventory and an updated inventory are costs that are borne by a museum or a federal agency. There are and have been since 1994 federal grants that are available to support that work in inventory of human remains and funerary objects. After an inventory is complete and a notice is published in the Federal Register, the work of requesting repatriation and then the physical transfer that may occur after repatriation, those costs are not defined as being borne by any party in particular. That should be a part of the discussion between museums, federal agencies and tribes and Native Hawaiian organizations on how that will be achieved and who will pay for it. Again, federal grants are available to help with the physical transfer process from a museum or federal agency to an Indian tribe or NHO. A question that asked me to comment on the removal of geographic affiliation and what implications you think it has for the consultation process. It's a good question. I will go back again to say we received a large number of comments on the concept of geographic affiliation as it was in the proposed regulations. That process mirrored very much the process that was under the previous regulations for geographic identification of an Aboriginal land tribe. The requests and the comments that we received largely asked that we make geographic information, retain it as a piece of cultural affiliation, and that where the only information available is geographic information, that it can still support a finding of cultural affiliation. So that is what we have put in the final rule. Certainly where the only information available is about the location of the human remains, and that can be the location either of where the human remains were removed or the location of where they are currently housed. In the law itself, it talks about geographic information, but also acquisition history as being ways of identifying cultural affiliation. So we have provided those both as options for identification of cultural affiliation. It is our hope that this will make a smoother consultation process, will provide more of the dialogue and simple exchange of information that the Act envisioned in the identification, particularly of cultural affiliation for human remains and associated funerary objects. We know that in another question, we know that in the 1970s and 80s, items, for example, false face masks, were repatriated. Is the idea that we should send out summaries of all objects and consult on them to be sure? I think that the answer here is that any museum or federal agency should ensure that the summary that it prepared of its holding or collection of unassociated funerary objects, sacred objects, or objects of cultural patrimony is broad and provides as much information as a museum or federal agency can about its collection, so that that information is available to tribes to make requests to consult or requests for repatriation. If you feel that what you submitted in the 90s for a summary is not sufficiently broad or is missing information, then certainly sending out additional information to potentially culturally affiliated tribes is a good idea. Do the regulations apply to any institution or office that receives federal support? For example, a police department that has human remains from an unmarked grave that may or may not be Native American. Related to this, how should institutions like laboratories handle requests to perform analysis on remains that aren't identifiable as Native American or not Native American, especially in light of the free, prior, and informed consent requirement, or to clarify, in the forensic context? We have certainly seen that medical examiners' offices, coroners' offices, and other local or state agencies, including police departments, that have possession or control of Native American human remains have obligations under NAGPRA. You can find a number of examples of notices that have been published by everything from the Michigan State Police posts to water authorities that may, for some reason or another, ended up with collections under NAGPRA. Certainly medical examiners and coroners' offices where the remains can be identified as Native American. The key is in that identification of Native American or not Native American. The identification needs to be based on the information that is available. So in a forensic context, that would depend on what information there is to show that the human remains are either Native American or not Native American, to make that judgment on when or if NAGPRA applies. Once we have consulted on a specific object prior to its exhibition, should museums assume that the object is safe to display for future exhibitions? Or should they plan to consult on all of those objects prior to all future exhibitions? It's a good question. I think the root of the question here is if we've consulted on a specific object and we have other similar type objects, is it okay to display any object that might be of a similar type? I think, again, the answer is to consult on that, because it may be that a particular object is not sensitive or not considered to be a cultural item by a tribe, but depending on the characteristics of a similar object, it may be. So I think always planning to consult on objects and planning to consult on exhibitions is a good idea. I would add that I think it is also a best practice for curation and exhibition. So beyond just NAGPRA, there are other considerations here on consultation prior to an exhibition. But again, it is important to consider what you know about the objects and to make your decision based on the information you have. And where you feel that you're lacking information, the best way to get information is to consult. Our institution has what we believe to be membres kill pots with questionable provenance. Excuse me. They are classic black on white with geometric patterns with a hole in the center. Do these fall under ceremonial or sacred objects that should be returned? somebody responded that they are almost certainly unassociated funerary objects in this person's experience. And would this include human remains that are believed to be Fremont based on materials excavated near the remains? Again, I can't speak to the very specific details here, and it is up to a museum or federal agency to make the decision on whether or not the information about these objects shows that it is a funerary object. That would be the first assessment to make. If they come from a funerary context, and then to determine whether they are associated or unassociated funerary objects. And all of those decision-making steps should be done through consultation. So again, I think the answer here is to consult on those objects and to proceed based on the consultation effort. I will add that you can also look to what other museums have determined. While there is no precedent under NAGPRA that one museum doesn't have to do what another museum has done, it can be helpful and beneficial. If you were to just search the Federal Register using the term NAGPRA and membres, you'll likely find several museums that have made a decision on objects similar to yours. Has the Department of the Interior or any other federal agency compiled ancestral homeland maps or other resources that institutions can access? Yes, thank you, Stephen, and for responding. We do have consultation resources on our webpage. It is under Getting Started. There is a resource library, and that includes a page on consultation resources. There are several resources that we've provided there for identifying contact information for tribes, but also for identifying different homeland locations or ancestral land locations. Thank you, Lisa, for providing that link. There are several resources there. I will note that the Department of the Interior, along with the Department of Agriculture, has recently provided a new resource for accessing treaties with the United States, and that is also linked on our website. And lastly, I will add that the National Association of Tribal Historic Preservation Officers, or NAGPRA, is currently working on a similar resource, and we have a link on our website to their working page. All right, I'm going to switch as the number of questions continue to grow and the time is running short to look at those questions that received the most upvotes. There is a way in Zoom webinars that you can echo a comment or a question that has been asked. And I want to be sure that I try to address as many of these as we can. I do want to note that if we run out of time, I will try to respond to questions either through Q&As, through frequently asked questions or other guidance documents that we prepare and make available on our website. All right. There seems to be a contradiction. If tribes are the ones who need to make a determination about the status of a cultural object, then it seems that any Native American object would need consent prior to research, access, or exhibition. Can museums make reasonable determinations that some Native American materials are not subject to NAGPRA, such as lithics or works purchased from artists, etc.? Again, I think that the issue here is in making an assumption. And as you state, there is an important role that tribes need to play here in the identification of cultural items under NAGPRA. I appreciate and understand that this seems like a contradiction. However, I would point to the legislative history in NAGPRA. And in particular, I would point to statements that were made by Senator Inouye on urging the passage of the act. The statement, which I'm not going to be able to provide correctly or accurately here, is summarized as where museums and federal agencies have positive working relationships with tribes, there is an easy answer to these challenging contradictions. But where there are not positive working relationships between museums and federal agencies and Indian tribes and NHOs, this is a more challenging decision-making process. So therefore, my best advice to you and my consistent advice is to start with that relationship building process, to reach out to tribes that might have an interest in these objects, so that you can proceed to making decisions about the objects in your holding or your collection. That is my best advice, and again, is not just a reflection of what is in the revised regulations, but is definitely the intent of Congress when they passed NAGPRA in 1990, that relationship building process. Certainly, there's a clear indication from Congress that this law was to give Indian tribes and NHOs more of an ability to negotiate on these questions of what is displayed and what is available for research. The question added then, does this mean halting any or all work or access to Native American collections pending consultation? Again, that is up to a museum or federal agency to decide, and it needs to be based on what you know about a collection, based on the information you have. And of course, where you feel you do not have enough information to begin the effort to consult on those collections to gain additional information. There was a request for a webinar on available federal grants, would be helpful. Especially since there will continue to be questions about duty of care and other consultation requirements. Thank you very much for that suggestion. I will say that we do have grants available right now. There is a notice of funding opportunity that is available both for consultation and documentation grants, as well as for repatriation grants. And those opportunities are open now, and the consultation grants close in March, early March. So if you do have a project that you can pull a proposal together for, now is the perfect time to make that application. However, we will add to our list additional webinars on those grants and those options. There is a wealth of resources on our website regarding those NAGPRA grants, and thank you very much for posting the link. Okay. Patty, I still see your question about options for museum to reinter, and I'm going to add that into our in-depth discussion in the next session in February for subpart C, because that process is an outgrowth of the other decision making that is required under subpart C. There's a question in the chat about the impacts on NAGPRA implementation of the Chevron deference, in quotes, that may be eventually overturned by the court, and in this case, the Supreme Court. Stephen Simpson, thank you for answering that. will depend largely on what the Supreme Court's decision is in the case that's pending. Okay, another question about summary templates. Will those be added to the website? Yes. And will the previous template continue to be appropriate? Yes. Both the summary template and the inventory template are being updated. We have pretty good drafts. We're almost ready for those to be published. But they're very similar to what we previously provided and very similar to what has been available since 1993 related to a template for an inventory or a summary. So where you have been using a previous template for a summary or inventory, those are still very appropriate to use. Will the updated template for an inventory be provided? Yes. And will information required, descriptions, accession numbers, catalogs remain the same? Yes and no. Again, we have tried to clarify in the regulations what is the minimum requirement for an inventory, for example. And while certainly it may be of benefit to your museum or to your own internal organization to include accession numbers or catalog numbers, that information itself is not the significant information that we in the National NAGPRA program or your consulting parties necessarily need. Rather, the geographical location as well as the acquisition history tend to be the key pieces of information that assist a tribe with cultural affiliation and assist with determining the proper repatriation of objects, of human remains, I should say, in an inventory. Therefore, we have removed the requirement for accession numbers or catalog numbers. They were included in the previous regulations as if available. They can be included. That's fine if that's how you need to organize your information, but it's not a requirement for an inventory. Again, I would point you to the regulatory language that we've tried to simplify and clarify, and that's in 1010A. And we have provided an example on our website of what an itemized list might look like. Some supporting comments here for consulting, and consulting again. Hey, I think that at least in terms of those questions with the most upvotes, okay. I'm wondering how these regulations relate to works made by Native contemporary artists. For instance, if a contemporary Native artist makes a work historically used in cemetery or in ceremony and sells it or donates it to a museum, should the museum seek tribal consultation? The answer to this question really comes down to to right of possession, I think, and looking at what you know about the acquisition of that object and if the museum has a right of possession to that object. I would encourage you to look more closely at the definition of right of possession, and then a museum should be prepared to have that evidence of right of possession to a contemporary item in its records. Question about museums in California that have responsibilities under the state law for consultation and repatriation of federally owned collections for which they have physical custody. Could I please clarify if federal agencies are responsible for consultation and repatriation under NAGPRA, even if the museum physically houses those collections? Under the federal law, a federal agency has responsibility for the collections that it has possession or control of. So if they are in the physical custody of a museum, but under the possession or control of the federal agency is responsible for the NAGPRA process under the federal law. Second, for CRM firms, we have collections from previous contracts from federal land. Some of the work was done decades ago and was never resolved. Federal agencies are responsible for consultation and repatriation of these collections and not the CRM firm. Is that correct? The answer to this question really comes down to the ownership of the land involved. There are specifics in the definition of federal land, and we have tried to clarify those in the revised regulations. We would encourage you here as a CRM firm to be sure that you are consulting with the federal agency to make a clear decision on who has that responsibility, whose land the objects were removed from, and who has then the resulting responsibility. A question: if museums are liable for penalties if a federal agency is responsible for repatriation and drags its feet. In some cases, we have been waiting over 16 years for our local agency office to publish and repatriate ancestral remains. There's a clear, clear distinction of federal agencies are responsible for those collections that are under its possession or control. And where a museum may have custody of those items, it is up to the federal agency to complete the process. I will add that under the revised regulations, there is a requirement for museums to send statements to federal agencies where the museum has a holding or collection that belongs to a federal agency. And it is our hope that through that process of sending statements and requiring responses from federal agencies, that these issues of who has possession or control can be clarified. You'll find that in section 10.8, letter C of the revised regulations are those requirements for museums to issue those statements and then for federal agencies to respond to those statements. I think that, again, I have answered most of the upvoted questions. Let me just do a refresh here and make sure that I'm not missing anything that a lot of you wanted an answer to. If a summary was submitted by a museum for a collection that is later found to be under the control of a federal agency, does the federal agency need to submit a new summary? The answer to that question is if the summary was sufficient for the federal agency's purposes or not, and whether the federal agency feels that it needs to revise or update that summary. Certainly, we think that the federal agency should contact tribes to let them know who is responsible for the collection and who can receive those requests for consultation or for repatriation of those cultural items in a summary. Again, we're talking here about a summary of unassociated funerary objects, sacred objects, or objects of cultural patrimony. You don't necessarily need to submit a new summary, but you will want to be sure that you're notifying tribes of who they should be contacting for consultation and repatriation purposes. Question: that is the deadline for summaries 6 months, while the deadline for human remains is 5 years. The former seems potentially more complicated to evaluate, again, as related to some of the questions here. It's a good question, and I would again turn to the legislative history. Initially, there was a requirement for all Native American objects in a collection to be itemized in an object by object list. Congress made a change to that requirement and required only summaries, a brief description, a general description of a collection of unassociated funerary objects, sacred objects, and cultural patrimony objects be completed. While identification of those objects does require consultation and is a complex process, it is not required to compile a summary. So therefore, the deadline for a summary is 6 months, which is the same as under the previous regulatory framework. For any new objects that were received, there is a 6-month timeline to complete that general description. But again, a general description, a much simpler project or effort to make information available to tribes about those summary objects, as opposed to the more detailed inventory that is required for human remains and associated funerary objects. A question about whether we will be providing an updated contact list, tribal contact list. We provide contact information through our contact database for both tribes as well as museums and federal agencies. Those are voluntary, so we only have information on those who share that information with us, but it is publicly available through our contact database. If the question is which tribes are Indian tribes under NAGPRA, the answer to that is in the Department of the Interior's list of Indian tribes with federal recognition is the list of tribes. In addition to that, I will say that for those federally recognized tribes, the BIA, the Bureau of Indian Affairs, does provide contact information. We are over time, and I appreciate everybody's attention and patience as we worked through a number of questions. I know that there are still a number to try to answer here today, and we will look at those and see if we can either answer them in following webinars or through some guidance documents that will be provided on our website. Again, thank you all for attending today, and we will see you next month.